The question is that this House do now adjourn. Mr. Karl Turner.
Thank you, Madam Deputy Speaker. I'm very pleased to have secured this very important debate on the effects of the reductions to legal aid on legal aid providers. I ought to refer members to the register of members' interests. It's right that I was a practising lawyer prior to my election to this House. Much of my income I relied on the public purse as a criminal lawyer. Madam Deputy Speaker, the Lord Chancellor offered up 23% cuts without any fight and blindly conceded to the Treasury's demands without looking at the real impact on justice and the impact on legal aid providers. The government's own impact assessment states that the lack of robust evidence base means that we are unable to draw conclusions as to whether wider economic and social costs are likely to result from the programme of reform or to estimate their size.
Honourable friend, give way.
Absolutely.
First of all, can I congratulate my honourable friend on securing this very important debate, but as a fellow Member of Parliament in Hull, he will know the importance of the CAB and the CLAC providing legal help and advice, and the real genuine concerns there are that people will not have access to good quality legal advice in the future, and I'm sure that he will share the concerns of many people in Hull. Absolutely.
My honourable friend makes a very important point. As I understand it, 97% of funding to the...
Order. Is it done?
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Mr. Karl Turner, you can continue now.
Thank you. As I was saying, Madam Deputy Speaker, some 97% of funding to the Citizens Advice Bureau will be gone as a result of this government's plan. So my honourable friend makes a very valid point. It's also important to say that it's not just the for-profit providers, it's the non-profit providers which provide very important legal advice to people in our constituencies. I just want to attempt to bust a myth which this government is perpetuating. There seems to be a suggestion that lawyers, publicly funded lawyers, are fat cat lawyers earning fat cat salaries. The reality is that publicly funded lawyers, whether it is solicitors or barristers, earn very modest incomes if they are funded by legal aid. The Lord Chancellor says that he does not want to hit women and children, but he does want to target fat cat lawyers. So why then is he making 53% cuts to social welfare legal aid?
Would my honourable friend, I'm most grateful to my honourable friend, can I declare my interest as a non-practising barrister? On the question of lawyers, I worked for a number of years as a solicitor at a law centre, and these cuts will actually affect some very poorly paid solicitors who work in law centres and who were previously doing work like immigration before that was taken away. So the profession itself will suffer because we won't be able to attract those to give them the expertise to do this kind of work.
Madam Deputy Speaker, my right honourable friend makes a very important point. It's a point which solicitors and barristers have mentioned to me in recent days. There's certainly a concern about attracting people into training contracts, attracting even people into studying law as a result of the plans of this government. Madam Deputy Speaker, as I understand it, £350 million will be removed from legal aid as a result of the government's plans. The vast majority of that will be in social welfare law. But just to attempt to bust the myth that publicly funded lawyers are indeed fat cat lawyers, I spoke with some legal aid providers in my area today. I spoke with Keith Lomax, the Senior Managing Partner of Davis, Gold and Lomax, based in Leeds. He represents the most vulnerable clients on such issues as housing, debt, welfare benefits and education, particularly special educational needs. He tells me that the government's reduction in fees of 10% across the board was pretty difficult for his firm to cope with. I was staggered, though, I have to say, that when he told me his hourly charging rate was £48.24. He charges the Legal Services Commission, indeed, £3.78 per letter. I mean, hardly fat cat lawyers' rates. The people who work for him earn very modest incomes. He tells me between £18,000 and £24,000 a year for fully qualified solicitors. Tim Durkin, the managing partner of Meyer Wolf Solicitors in Hull, owns a long-standing firm reliant on legal aid. Mr. Durkin tells me that he estimates the cuts to his business in relation to child contact and residence applications will amount to something in the order of £300,000 per year. He describes that as simply unsustainable. Max Gold from the Max Gold Partnership in Hull reports to me that he's not been in a position to pay himself an increase in salary or his solicitors and staff for some 6 years. He says the government are not living in the real world to describe legally aided lawyers as fat cats. The Labour government was far from profligate in terms of legal aid, in his view. He says that the previous government were not generous, particularly in relation to publicly funded lawyers. But what he does say is that the previous government at least understood the requirement to offer legal advice in areas such as social welfare law. And indeed, he mentioned the issue of immigration, which is a particularly important point, given that the other place almost accepted an amendment, but was defeated, I think, by 19 votes a couple of days ago. Madam Deputy Speaker, in the year 2000, there was 10,000 legal aid providers. There are now 2,000, a reduction of 8,000 firms in the last 12 years. Many of these have closed the doors in the last 12 months. The impact of these cuts on legal aid providers is very clear for anybody to see. Many firms who provide mainly family and social welfare law will have to withdraw from the market. The Law Society says firms already operate on margins of viability. Specialist firms and advice agents providing welfare law services are likely to be wiped out, with catastrophic consequences for people in need of legal help. The Law Society does not see how many firms can continue to operate in this environment. Current changes could reduce firms offering family law by as much as 60%. The government's own impact assessment accompanying the Green Paper estimates that 67% decrease in income for rural area law firms and 59% decrease in urban areas. It's simply unsustainable. It's not economically viable for these firms to continue to offer these services on such tight margins. The Legal Action Group believes that legal aid will cease to be viable as a nationwide public service, with an overall decrease in civil legal aid to 900 firms, down from 2,000. The clear concern for me, Madam Deputy Speaker, is the potential for advice deserts as a result of these reductions. The impact, therefore, on access to justice is very clear. If no service is available, our constituents will be left to paddle their own canoe. 75,000 children and young people are set to lose legal aid. 6,000 children under the age of 18 and 69,000 vulnerable young adults aged 18 to 24 will lose access to legal aid in their own right as a result of the Legal Aid Sentence and Offenders Bill. The government claim advice will be available elsewhere, from places such as the Free Representation Unit, the Job Centre and Age UK. This claim has been disputed by the Advice Service Alliance. The Free Rep Unit represents clients in tribunals, but it does not cover the initial advice stages of, say, a welfare claim. The Child Poverty Action Group stated, unfortunately, we do not have the resources to provide direct advice to people who are claiming benefits. They say that their concern is that while it is true that both Age UK nationally and our partners in local Age UK's age concerns do provide some legal advice with welfare benefits, it's most often not a level comparative to that provided through legal aid. And the government's defence to this, up to now, Madam Deputy Speaker, has been the telephone advice service. This is not the answer to the advice desert situation. Face-to-face legal advice is absolutely crucial. Fortunately, the government suffered a defeat on this issue in the other place yesterday evening. I would respectfully urge the government to take this on board. The Ministry of Justice only predicts between 4,000 and 10,000 additional mediation starts, despite withdrawing legal aid from 255,000 cases. They've simply not made a proper assessment. The impact on both for-profit and not-for-profit providers will be substantial, but it will be most keenly felt by those that rely on their services. The government's own impact assessment states the proposal have the potential to disproportionately affect female clients, BAME clients and ill or disabled people when compared with the population as a whole. Despite that advice and evidence, the government seem to want to plough on regardless. At a time, Madam Deputy Speaker, when unemployment is rising and pressure is increasing on squeezed families, it's wrong for the government to be withdrawing support for legal advice. Opposing the legal aid cuts is not done due to narrow interest or to ensure that lawyers' bank balances stay buoyant. It's about ensuring that people do not just have rights, but they have the means with which to exercise those very important rights. The government must listen to the experts and base its cuts on evidence. The Justice Select Committee, which I serve, has said the full cost implication of the government's proposals cannot be predicted. I would therefore ask the government to reconsider these cuts and not to take a gamble with justice. Many eminent judges have also voiced their concern, not least Lord Hope, Lord Justice Dyson, Lady Hale, and academics and professionals have told the government time and again that there will be an increase in court administration due to litigants in person, but this has been completely ignored. Indeed, the Lord Chief Justice has echoed these concerns. The opposition to social welfare legal aid is, for me, about protecting the vulnerable and allowing access to justice. It must also be about saving money to the taxpayer. Of course, we are living in times of austerity, but there are alternatives. The early intervention provided on such as debt, employment, education, housing, family law, provided through a mixture of voluntary and private sector organisations, provide real value for money. I'm not going to bore the Minister with the statistics produced by the CAB, but they've provided members with a very helpful report explaining pound for pound the advantages of providing early advice. But unfortunately, Madam Deputy Speaker, the Tory-led government have ignored crucial advice. From, as I've said, the Lord Chief Justice, the Bar Council for England and Wales and the Law Society. The Lord Chief Justice stated that the proposed reforms of public funding for civil cases will damage access to justice and lead to a huge increase in fighting their legal battles alone. It's obvious to anybody that litigants in person will delay court time. The Honourable Member for Swindon is in his seat. He sits as a recorder in the Crown Court. He would know, he must know from his own experience the advantage of having a solicitor, advocate or a barrister representing a client in court as opposed to a self litigant. The chairman of the Bar Council, Michael Todd QC, has told me today that legal aid barristers working across a broad range of practice areas are public servants, overwhelmingly operating in the public interest. Over a number of years, many members of the bar, and the junior bar in particular, have found it increasingly difficult to sustain a financial viable career on legal aid work, which poses a grave threat to access to justice. He continues, successive fee cuts and now the threatened removal of whole areas of law from the scope of legal aid means that many vulnerable people will be denied effective access to the courts. It also means that many highly skilled, publicly spirited barristers will be forced to leave the profession with a particularly heavy impact on female and BAME practitioners. That cannot be in the public interest. Madam Deputy Speaker, the Lord Chancellor needs urgently to take on board the defeats the government have suffered in the other place and re-look at the real impact on these legal aid cuts before overturning them in this place. Thank you.
Minister.
Madam Deputy Speaker, and I declare any interest I may have as a non-practising solicitor. Firstly, let me congratulate the honourable gentleman for Kingston upon Hull East for securing this debate today. I do recognise that this is a timely and important discussion to be having at the current time. And let me start by saying that measuring and understanding the effects of legal aid, sentencing and punishment offenders bill on the providers of publicly funded legal aid services is something that the Department has been committed to throughout the policy development process. And I would invite honourable members to consider both the impact assessments and the equality impact assessments published alongside the government's consultation paper and the response that we did to that consultation. These are extensive in their consideration of the impact of the reforms on legal aid providers, with the equality impact assessment providing very granular detail on the potential for differential impacts in respect of different provider types, whether solicitors, not-for-profit organisations or barristers. We do recognise that such assessments have their limitations. They use a method analysis referred to as counterfactual assessment. This operates by taking a given set of assumptions, in this instance a snapshot of income in the legal aid market in a given financial year, and applies a narrow set of changes in this snapshot, here the reduction in income implied by the changes in the bill. What the assessment cannot do is measure matters such as how providers will respond to these changes in terms of the structure of their firms, the business model they employ, their employment profile, or the areas of law covered by their organisations. And this is a crucial point for me in the debate here today. In other words, one cannot say with any real certainty how individual providers will respond to those changes. And this will be a major factor in the overall effect experienced by the providers of legal aid. However, following our commitment made in the consultation response, we have now commissioned a study which we hope will provide a better understanding of the dynamics of legal aid providers. It should also be recognised that our discussions today are not purely theoretical. And I simply do not recognise the picture of a failing environment for providers that was set out by the honourable member. Almost half of the savings being taken from legal aid for the spending review period are derived from the remuneration changes implemented last October, which have now been in operation for up to 6 months. And there have been no discernible negative impacts on the supply. In fact, there has been strong confirmation that the market is willing to work at the new rates. The most recent Legal Services Commission tenders for family work were conducted using the new reduced rates and were oversubscribed. This suggests that the rates offered are sustainable and that providers are able to absorb and respond to the impact of reduced fees. But returning to the bill, at the macro level, there are of course some obvious realities, and I have always been very open about these, as the honourable gentleman will know, both in Parliament and in my extensive engagement with the sector. A contraction in the range of services funded under legal aid will most probably mean a contraction in the number of firms providing such services. as well as a reduction in the numbers of lawyers practising in legal aid. But I disagree that this should translate into widespread advice deserts, which is certainly not the case at the moment. This is a natural corollary of the changes we are making to scope, and I make no apology for this. I agree with the honourable gentleman that in most, but not all cases, this is not a debate about so-called fat cat lawyers. The legal aid system is there to provide advice, assistance and representation for those who need it most, not to maintain existing supply levels of lawyers. But we do, of course, need a sustainable provider base, because without those delivering services, there would be no legal system. And to this end, we are finalising our approach to the first round of contracting under the new scheme, which we anticipate commencing soon after royal assent. There are, of course, two sides to this coin, and sustainability is not something government, as the purchaser of services, can or should provide purely on its own. No market is static, and nor should it be. The legal aid market has historically shown itself to be adept in responding to changes and seeking out commercial opportunity, and I see no reason why it should not do so again. In order for any business to thrive, it must be flexible and adaptable. This is true of any sector, and government is creating the conditions that will allow legal aid providers to flourish. The Legal Services Act 2007, for instance, establishes a new licensing regime, which is now fully operational. This affords more flexibility, innovation and opportunity in the type of business structures and providers able to offer legal services. The significance of this particular change and the commercial opportunity it represents cannot be overstated. That is not to suggest that innovative models possible under that Act are the only way for providers to remain sustainable under the new scheme. Indeed, the impact assessment figures published alongside the government response to consultation suggest that even after the reforms have been implemented, there will still be somewhere in the region of £1.7 billion spent annually on publicly funded legal aid services. So after the savings, we will still most likely be spending more than any other country on legal aid. And it is therefore undeniable that this level of expenditure represents a viable market. Furthermore, given the range of services that will still attract funding, it is open to providers to diversify and seek income across a range of areas of law. Equally, for some providers, the most prudent option will be to concentrate on their area of core expertise and expand their market share in a particular field. It will also be possible to bid for complementary services. Government has made its commitment to alternative dispute resolution clear and expects to fund an additional £10 million in mediation services under the new framework, and the LSC will be tendering for additional mediation contracts to provide these services. The introduction of the new mandatory telephone gateway, which was mentioned by the honourable gentleman, and which I can say we do intend to reinstate to the bill, also presents opportunities, as providers can, as now, run telephone-based contracts alongside face-to-face contracts in those areas that will still attract funding. The overall message I want to get across here is that although challenging and sometimes traumatic, these changes will not come without opportunity, provided that there is a willingness to engage with them and think constructively about how to respond to such changes. Though steeped in great tradition, the legal profession has throughout its history demonstrated resilience and fluidity, and I would expect nothing less in response to these changes. There are, of course, as the honourable gentleman mentioned, those outside the private legal profession that are affected by these changes. And as mentioned by the honourable member, and as well the honourable member for Kingston, Hull North, I believe, the equality impact assessment also considers the likely impact of the proposals on not-for-profit organisations. A number of the areas removed from scope under the bill are traditionally areas in which not-for-profit bodies have a significant presence. Coupled with local authority reductions in funding for such organisations, government fully recognises the cumulative effect these changes could have. However, as I have made consistently clear to the House, government recognises the benefits that early generalist advice can have in a range of contexts and wants to support the sector in continuing to deliver such services, but not necessarily in the context of legal aid. And to this end, we have already seen the creation of the £107 million Transition Fund and the £20 million Advice Services Fund to help the sector transition through the changes being delivered under legal aid and beyond. In addition to this significant funding, the Chief Secretary to the Treasury has now indicated that additional funding beyond this financial year will be made available to provide further support to the sector as part of the forthcoming budget statement. This underlines government's commitment to the provision of such advice services and should serve to ameliorate the effects of funding reductions. However, this is not to say that everything will be the same as it was. Our fiscal position, as the Honourable Gentleman admitted, is such that savings must be made, and the not-for-profit sector will need to demonstrate the same adaptability and resilience that I've already described in respect of the legal profession. In summary, I do want to emphasise, Madam Deputy Speaker, that government understands and is sympathetic to the scale of change that this bill represents. But we also wish to stress that it is incumbent on the providers of services to think constructively and creatively about how they will establish themselves in the new marketplace. Change will naturally be a challenge to the sector, not least given that the current system has operated for a significant time and providers will have become accustomed to a particular way of working. However, for the reasons that I've given, there will, I believe, be real opportunities available to those who wish to take them. And for those outside of the scope of the new scheme, additional funding, as I've said, is being made available to provide for the future. So to close, I do want to see a return if I just finish by returning to the rather technical-sounding counterfactual assessment I referred to at the outset and its interaction with our discussions today. In effect, we must avoid falling into the trap of predicting the future on a basis that doesn't allow for the very human response of adapting to changing circumstances. There is a future for legal aid providers, and the market can thrive, but the willingness of providers to adapt will be a key to achieving this. Given what I have seen to date, not least providers' response to the fee reductions, I have every confidence that this will be achieved.
The question is that this House do now adjourn. As many of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it. The ayes have it. Order. Order.